A $2.18 billion jury verdict against Intel. Vacated. Not by new evidence. Not by a dramatic courtroom reversal. On appeal, the core of the argument from Intel's legal team, a 2012 license agreement with FinGen they claimed, should have shielded them because Fortress Investment Group controlled both FinGen and VLSI technology under an affiliate provision. The Federal Circuit held the district court had abused its discretion by blocking that defense. The decision sent a shockwave through patent litigation. It meant a defense tied to contracts made by others, years before, could now be heard. For Fortress Investment Group, the entity backing VLSI, the rulings threatened to unravel a multi-billion-dollar verdict. To understand how this happened, we have to rewind past the Texas courtroom drama, back to the corporate deals that created these patents in the first place. The patents at the heart of this conflict did not originate with VLSI as an operating chipmaker. They came from a semiconductor portfolio later associated with NXP lineage assets and were asserted by VLSI Technology LLC as a patent assertion entity. The claims targeted processor functions juries were told mattered to power management and performance. These were not framed as trivial side patents. They were aimed at the economic core of modern microprocessors. VLSI Technology LLC, a Fortress Investment Group-linked monetization vehicle, not the historical VLSI chip brand in its old manufacturing sense, existed to turn patent rights into courtroom leverage. The targets were not obscure side products. Assertions reached flagship Intel processor families covering core architecture and performance features. In the Western District of Texas, that strategy produced headline jury numbers. One trial path produced a combined award of about $2.18 billion, $1.5 billion on one patent thread, and $675 million on another. A separate Texas trial produced roughly $949 million more. Those figures were among the largest patent infringement jury headlines of their era. They were not the same thing as cash Intel had already paid. Verdict Inc. is not a wire transfer. The campaign looked, on paper, like a masterpiece of monetization, but every Skyline jury award still has to survive the Federal Circuit and a license theory rooted in who controls whom under Fortress. The Texas verdicts were not a conventional product war between two chip factories. They were the product of a specialized financial strategy associated with Fortress Investment Group and VLSI Technology, LLC. VLSI, in this litigation posture, operated as a non-practicing entity. It did not need to ship processors to extract value. The strategy was to assert patent rights and convert favorable findings into damages pressure. One side designs silicon, the other prices risk. That created asymmetric warfare. For Intel, years of multi-front patent license defense diverted legal attention across product families, with billions in revenue at stake. For VLSI and its backers, litigation itself was the product. The war chest only needed to outlast the defendant on the docket calendar. Venue mattered. Much of the headline fighting ran through the Western District of Texas, a court that, in that era, became a frequent destination for high-stakes patent trials. Whether you call that strategy or forum shopping, the effect was the same. Intel was forced to defend core processor products in a high-velocity patent forum. The strategic question underneath every filing was control. Not only who owned a patent number, but whether affiliate and license structures under Fortress could rewire who was allowed to sue whom. If VLSI and FinGen were under common control, Intel's older license theory could become a shield. That assumption would move from footnote to battlefield. In the Western District of Texas, VLSI's legal team methodically constructed its case. The argument was direct. That features at the heart of Intel's flagship processor lines, specifically related to power management and memory access, were practicing technologies covered by patents VLSI acquired from NXP, Freescale, and other semiconductor predecessors. Attorneys presented evidence aiming to show that the architecture of certain Intel chips implemented the patented inventions. The strategy was not to pin infringement on a peripheral feature alone, but to put high-volume products in the crosshairs of specific claims. For the jury, the case was framed as unauthorized use of proprietary technology. Keep the verdicts separate. They are not one pile of cash that moved as a single unit. In March 2021, a Texas jury returned a combined $2.18 billion award on 2 patents in the first VLSI trial, $1.5 billion tied to one patent thread and $675 million to another. That was Trial 1. Later, in a separate trial on a different patent, the 552 matter, a jury returned approximately $949 million. Combined headlines talked about $3 billion of jury exposure. Headlines are not the same thing as final, collectible judgments. For Intel, those numbers were a serious balance sheet and product risk. The company challenged claim construction, infringement theories, damages, and a license defense linked to a 2012 FinGen agreement and Fortress control of related entities. The company was cornered in the sense that Texas juries had found infringement on specific microprocessor features, not in the sense that a single appellate order vaporized every thread on the same day. The Federal Circuit later rewrote the $2.18 billion path. It affirmed infringement on one patent, reversed infringement on the other, vacated the damages award for the surviving patent, and remanded damages for a new trial. The $949 million path remained a separate proceeding with its own post-trial and license fights, not a carbon copy of the first appeal. By 2024 and into later proceedings, both tracks were still being litigated as distinct appellate and district court stories, not settled as one fused settlement of $2.18 billion. But $3 billion in jury headlines can still be a paper tiger at the Federal Circuit, the specialized U.S. Appeals Court for Patent Law. Intel appealed. Counsel attacked claim construction, infringement theories, and damages architecture, not with a public relations plea, but with a technical strike on how the patents had been read to a jury. Separately, Intel fought to revive a license defense, that a 2012 FinGen agreement should cover VLSI patents if Fortress control linked the entities. The Federal Circuit rewrote the scoreboard. In the $2.18 billion path, the court affirmed infringement on one patent thread while vacating the damages award for a new trial, and reversed infringement on the other thread that had carried $675 million. The combined Texas jackpot did not travel intact up the appellate ladder. Appeal is where spectacular numbers go to be audited. The $949 million path did not freeze in place either. License and control questions, including whether Fortress control of VLSI and FinGen opened Intel's license theory, became central after the Federal Circuit refused to treat that defense as forever locked out. Jury ink from Texas was real. Finality was not. That is the real lesson of the multi-billion chip patent war. A district court skyline is only Chapter 1. Chapter 2 is whether the Federal Circuit leaves the skyline standing, and whether a control chart at Fortress can erase it. The $2.18 billion path and the $949 million path are separate proceedings. They did not vanish into a single settlement. On the first, the Federal Circuit left a mixed map. Infringement affirmed on one patent thread, reversed on another, damages vacated and remanded for a new trial on the surviving award. On the second, the $949 million verdict had its own post-trial and license fights, including later jury proceedings over control and license theories. Jury ink from Texas was real. Final collectible judgment is a different question, and it is still status-dependent by track. For Fortress and VLSI, the strategy of asserting an acquired semiconductor portfolio in a favorable venue survived trial headlines and then met appellate and license scrutiny. The multi-billion-dollar skyline from the Western District of Texas did not travel intact up the appellate ladder. That is not the same as saying every claim disappeared overnight. For Intel, this was never best told as corporate extinction. It was a multi-year patent war with real damages risk on product lines, and a reminder that appellate review and licensing history can rewrite a trial scoreboard without rewriting the company's entire business. The signal for the industry is doctrinal. It is a stark warning. A massive jury award is not a final trophy. It is a provisional victory, vulnerable to claim construction, damages methodology, and foundational contracts that predate the plaintiff of record. The case proves that a patent's past can be its most fatal flaw. The risk calculus for patent monetizers and their targets has been rewritten. The question for any company building or buying a patent arsenal is now different. It is not only, is this technology infringed? It is also, what forgotten contract, what decades-old deal, what control chart could collapse the enforcement strategy after the jury goes home? If this analysis clarified the legal stakes, a like helps us reach more curious minds. What does it signal when a defense wins on contractual history and appellate rewrite, not only technical non-infringement? Drop your verdict in the comments.